I'm Dumitru, Intellectual Property Advisor with an organization you mentioned, Canadian Intellectual Property Office, in short, CIPO. I worked first with the CIPO as a patent examiner, then I moved as an intellectual property advisor, advising people how to take advantage of the intellectual property system in general. So my role is in educating Canadians to benefit from the intellectual property system. Today I will present you Protect Your Brand, and in particular talk more about the intellectual property right concerning the trademarks. We also talk about traditional knowledge and intellectual property, how they interact, and what forms of IP might be applicable to creations from related to traditional knowledge. Next slide, please. So this is the agenda of the presentation. It's a full presentation with lots of slides, but visuals, and you'll be able to grasp quickly the subject matter by looking at the slides. We will start with a quick overview of main types of intellectual property in Canada. Then we'll try to define trademarks, what trademarks are, how to choose a trademark. Then we'll talk about trademark consideration in general and also in relation to traditional knowledge. We will cover traditional knowledge aspect also with other forms of intellectual property, with examples that will be very valuable for entrepreneurs dealing with creations from the traditional knowledge field. We'll also talk about the value added by the trademarks to the brands, and we'll end with a summary and with a link to our organization, where you can find more information about intellectual property aspect, and in more detail you find different web-based tools, manuals, videos, tutorials, that well, plethora of information regarding intellectual property that might enable you to learn more and use effectively the intellectual property system. Next slide, please. So next slide presents different types, main types of intellectual property we find in Canada: trademarks, patents, copyright, trade secrets, industrial designs. And we will cover them with the examples in the slide that we have for traditional knowledge creations. These are the main types of intellectual property that you'll find in Canada. You also have like a more specialized form of intellectual property, like plant breeders' rights or integrated circuit topographies or personality rights. We will not cover during the presentation. However, you find information about all these rights on our website, as I mentioned. A few words about different forms of intellectual property in general. They depend on different kinds of creations. So trademark rights as a form of IP will be applicable to brands, and we'll go in further detail. Patents will be applicable to creations from the technological scientific field, inventions. Copyright deals with the protection for the cultural related works, and that's quite important for cultural relations dealing with traditional knowledge. Trade secrets is a contractual obligation. It's a confidential form of IP. How it works is that it may cover creations related to a product, but also to a trade. Might be like a list of suppliers, a list of potential clients, parts of the business plan. This might be covered by trade secrets. Industrial designs cover the visual aspect of a product, original shape, configuration, pattern, ornament that apply to a finished article. So these are the main types of IP. Other characteristics, they are territorial in the sense that they go country by country with some exceptions. Copyright might be one exception because Canada signed the International Convention regarding the copyright. Another common aspect of these types of intellectual property is that they are limited in time. After they expire, they become public domain. Trademarks might be, in some instances, considered unlimited in time if they are properly maintained and registered. They are these forms of intellectual property are not self-enforcing. It's important to mention here. So once you formalize a form of another of intellectual property, the intellectual property owner has an obligation, so to speak, to police to see if these intellectual property rights are respected. If someone is infringing, the owner should take appropriate action. All these forms of IP actually start in terms of ownership with the creator, and that's quite important mentioned because when we deal with creations from the traditional knowledge, here it's in some instances it's difficult to find who is the creator or the joint creators. Next slide, please. So in the next slide, we define trademarks. Trademarks are actually signs that define products and services of different persons. They have to point, when you see that kind of sign, they have to point and give an indication who is controlling the quality of the product and service, the provider of those products and services. That's quite important. Otherwise, if there is confusion, it doesn't give a clear indication who is behind, then a conflict situation might arise. These signs might be traditionally words, sounds, and designs, may also be a so-called non-traditional signs or trademarks, moving images, holograms, scents, and tastes. Next slide, please. So when, in the next slide, if you have examples of some signs that are related to trademarks. First, you have that traditional sign that has been mentioned in the previous slide. So a word, a slog, a design, and a sound, and non-traditional trademarks as well. And that sign has to distinguish products and services of different persons that I mentioned. Company name, the legal name of a company may be used as a trademark if it performs that kind of function. I mean, identifies products and services are used as an identifier. The same with the domain name may work as a trademark. So next slide, please. An example would be, next slide shows an example of this kind of trademarks that are used. Tim Hortons is a famous Canadian trademark. The word sign Tim Hortons, it's considered a trademark, identifies the products and services offered by the Tim Hortons Incorporated company. And the domain timhortons.com gives the internet address where you can find the information about that kind of company, and they can sell even products on their website. But if you use this kind of Tim Hortons Inc. to identify products and services of Tim Hortons company, then might be considered a trademark. So And many companies use the trademark system by registering their company name as a trademark, and also in some instances registering trademarks or formalizing trademarks rights for a line of products and a line of services. Next slide, please. Keep in mind that when you're choosing a trademark, some other rights might be, intellectual property rights might be applicable. So you have an example here with a trademark and the image of the Michelin Man. So the logo, if it's used to identify the company's products and services in Michelin, in this instance, works as a trademark. But also because it's an artistic work, the owner of that copyright has the right to stop others of simply copying this kind of images, regardless of what, how the images are used, for example, for identifying certain products and services. And the same with the industrial design. You have Coca-Cola bottle as an example, because the shape is that kind of sign, distinguishing guise, we call it in the trademark field, that identifies this kind of non-alcoholic beverage that works as a trademark. But also the particular shape, ornamentation of that kind of bottle may be protected by industrial design with another kind of right, and also limited in time. Next slide, please. When in the next slide, we will see different consideration that you should be aware of when you're choosing a trademark. So a trademark should be distinctive first, but also cannot be clearly descriptive. And we'll see there are some exceptions. It cannot be the person's full name or surname. However, we've seen in the previous slides the name of Tim Hortons. So yes, might be used the person's full name and surname, but under certain conditions. But when you start registering a trademark, unless you have like this kind of name, it's backed by proper marketing promotion, I would say, to make it work as a trademark, and we'll see the example in the next slide actually, may work as a trademark. The same time, name of product and service in other languages are not considered suitable for trademark. And obviously, when you try to imitate someone else's trademark, you go close to how they look. For example, in that situation, it will be confusing. The trademark will not point to just one producer, to different producer, and the customer, the buyer, will be confused. In that situation, it's a conflict trademark situation. Next slide, please. So here we talk about that kind of exception when choosing a trademark. You may actually use Tim Hortons of Mercase and also super fresh fruit and vegetables if you do such a promotion that the customers will be aware, or they will know who is behind that particular trademark, and it has to be just one person. Next slide. Here, when you start the process of adopting a trademark for registration as well, and we will see later on that there are two options in Canada. You may have protection under without registration, and also you may enhance the trademark protection with a registration. But what you'll do when you start considering adopting a trademark, you'll search to see whoever else adopted or registered a similar kind of trademark. So you'll search the trademark database. In Canada, you search CIPO's trademark database. United States, you have United States Patent and Trademark Office database, and you can search there. In European Union, you have a European Union trademark database. So you would like to make sure the trademark you will adopt will be distinctive, different from the others, especially in the same field. It will not create confusion. Next slide, please. So how much it will cost you in Canada to register a trademark? You have here the latest fees. You apply, you have an application fee of $478. And that includes one class. If you'll add other classes, I mean, you'll identify products and services from different classes, and you'll have a manual with trademark classes that you'll may consult online. So you'll adopt, for one class, you'll pay just the basic fee, but if you are interested in using the trademark for additional classes, you'll have to pay extra. The trademarks, once registered, they are valid for 10 years, and they may be renewed. You may be renewed, or you pay a fee, and at that time you may also add other classes for the same trademark, and you'll pay that kind of fee. Usually people hire registered trademark agents and lawyers to give them an advice, and we'll see later what kind of service they can offer you. And you have to pay them extra. But in I think yeah. So in the next slide, we will talk about what kind of, next slide, please, now, if I may. So here, you have in the previous slide how much it will cost you to register a trademark, but keep in mind that you may have basic protection in Canada under the so-called common law. So registration has certain advantages. It gives you an additional evidence of ownership. It may be enforced throughout Canada, regardless where you'll use it. But under common law, the protection depends on the evidence of distinctiveness. You have to be to show that you have a distinctive trademark compared to other trademark used in the same field of trade. And the protection under common law is limited geographically. So that's to keep in mind that the registration will give you that advantage that you can enforce the trademark rights throughout Canada. And keep in mind that trademarks are territorial, so the trademark protection system differs from country to country. And the main difference would be that in other jurisdictions, in order to enforce your trademark rights, you have to register that. You don't have, like in Canada, common law trademark protection based on use. Next slide, please. So we talked, next slide, please. Yeah, we talked briefly about the services of a trademark agent or lawyer. So it's highly advisable to consult such a professional, because such a professional might help you to give you a legal opinion on the scope of protection you can have. The professional may also give you a rough estimation of how much it will cost. And you'll be able to have or to establish a strategy on where I will protect my trademark rights in Canada and other jurisdictions, in what jurisdictions, how much it will cost. So there is an international mechanism of applying for a trademark registration in many countries. It's called Madrid Protocol. And I suggest that if you are interested in, to go on our website and see how it works. So it's quite important in order to work effectively with this kind of professional to understand different types of IP. And that's our role a bit, to educate you what are different forms of IP and how to take advantage of the services of an IP professional by being well informed, knowing exactly what you are looking for, and be aware of how much it will cost. It's good to do a prior quick search before consulting a professional, and also think about where you'll consider getting trademark protection in other jurisdictions. Next slide, please. This kind of professional have a lot of expertise in terms of IP. Here, this slide presents you different types of IP expertise a profession has. For trademark purposes, they can check for trademark availability and give you a legal opinion on that. They also can help you in the drafting and writing your trademark application. Basically, they will help you to choose the trademark and also list those products and services associated with that particular trademark that have to be part of the trademark application. Then may take care of filing the trademark application and also process the trademark application. And other forms of IP, patents, industrial designs, for example, they are professionals in the field and they are highly recommended to be used. The system allows to do it yourself or with help with a professional. However, talking about patent field, patenting is a complex process. It's costly, it takes time. It's highly advisable to hire a registered patent agent or lawyers for that. Next slide, please. Let's talk now about traditional knowledge. Let's start with the definition of the traditional knowledge. It's the knowledge, know-how, skills, practices that are developed, sustained and passed from generation to generation in a particular community, and they form part of the cultural or spiritual identity of that community. They have certain characteristics, and here are listed. They are handed, as mentioned, from generation to generation. They are also like representative of the community's culture or spiritual identity. They are also location and culture specific, and that's quite important. We'll see when you'll seek to protect this kind of geographical indication of the location the community is situated. Unfortunately, it's not systematically documented, and quite important for getting intellectual property rights to have this kind of documentation. For example, copyright work protects what is a fixed work. It's important to have some sort of documentation in order to follow a particular creation with an intellectual property right. It's not typically traceable to a single author or inventor, and that's quite important because you cannot have, using the traditional intellectual property system, you cannot have protection when you cannot define who is the author. It has to be like a clear chain of title from the author to the latest owner of the intellectual property rights. But these creations from traditional knowledge. They are constantly evolving and being recreated. And here you may kick up with an intellectual property right that will be applicable for improvements, for different adaptations of creations of related to traditional knowledge. Next slide. So advices for entrepreneurs, how they can benefit from the traditional knowledge and the intellectual property. First, they can have a say, or they have an interest in preserving the traditional knowledge and contribute to the protection from the risk of cultural misappropriation and misuse. We will see some examples here as well later in the presentation. So they should help control and access the traditional knowledge. Fortunately, there are many commercialization opportunities because a lot of creations from related to traditional knowledge, they are natural and authentic products, and that's what people are looking for, and they are ready to pay more for this kind of products. There are also creations dealing with indigenous traditions, practices, symbols, designs, textile. We'll see they are very popular these days, and people are looking to buy them. So the entrepreneurs in this field may take advantage of this kind of trend. Licensing the traditional knowledge is how you can commercialize the intellectual property. So you have to define intellectual property in a licensing agreement, and then negotiate the proper licensing fees, so you may commercialize different creations related to traditional knowledge in that way. Next slide. So let's see what kind of general approaches you might have to intellectual property when it touches the traditional knowledge. So you may consider defensive protection. That means in stopping others of getting intellectual property rights, exclusive rights for something that they are not entitled to, actually, creations from the traditional knowledge. You may also have an offensive, we call it protection. Probably it's not the best wording for this kind of protection, but what it means that you are seeking in using the intellectual property system to protect creations coming from or related to traditional knowledge. So you may benefit from the existing intellectual property system, getting patents, copyright, and other forms of IP that will help you enforce your rights and get protection for creations from related to traditional knowledge. So we'll see examples. Probably it's a bit too general saying just you have two kinds of IP strategies here. One will be defensive and one offensive. But going to the next slide, please. You see here example of a trademark. Actually, it's a certification mark. It defines a standard. So the government of Canada established that kind of trademark, certification trademark, to help protect Inuit artists from copyright infringement. So that's the power of using the trademark system, the traditional trademark system, as a certification mark. So it's clearly a trademark. It differentiates products and services from others. The protection is based on use, and the registration, a valid registration, is based also on use. Once you get registered a trademark, you have the right to exclude others from using the mark for as long as you have the trademark rights under common law, for example, or registered. If you register the trademarks, you get 10-year registration period and may be renewed indefinitely, and the registration is in good standing if you'll use it. So it's important to inform others, as a tip here at the end of the bottom of the slide. Mark it properly. Inform people that this is a trademark of yours. You may do that before the registration, and you may use an R encircled after the registration. Next slide, please. I mentioned briefly when I talked about traditional knowledge definition about the indication, geographical indications. That's quite appropriate for many creations coming from or related to traditional knowledge. So what the geographical indications are, they are trademarks actually, that are used to protect the quality and reputation of agricultural products. The characteristic of this product, or they have to be related to a geographical origin. The registration is possible with the trademark office of the Canadian Intellectual Property Office. So the registration or the trademark protection is related to the location, not to a company. Keep that in mind. Usually an organization that deals is representative for that kind of location register this kind of geographical indication. So that is the responsible authority. An organization that also can use that kind of trademark protection, geographical indication, to enforce it, to stop others of using a similar like indication when the product is not a genuine product from that particular location. And here you have the example of Charlevoix lamb. It's produced there. It's quite a famous geographical indications in Canada. Next slide, please. So patents might be applicable for creations from the technological, scientific field that actually relates to traditional knowledge somehow. And here you have an example of a composition of matter, actually, that has been a medication, actually, and was a patent applicant tried to get the grant of a European patent, but they had to withdraw that kind of application because it was found that the composition of that particular drug medication was based on a creation or related to traditional knowledge, and that was rebus, red bush in the Afrikaans language. So in general, you can get a patent for this kind of technological scientific creations that are related to the traditional knowledge, but they have to be new, useful, and inventive. Once you get the patent granted, you have to apply and submit full disclosure of your invention in the patent application. Once the patent is granted, the protection lasts for 20 years and then consists in your exclusive right to stop others of making, using, or selling what you claim as your invention. There is a 12 months grace period before applying, in the sense that you may publicly disclose the invention, give information about how to build the invention, but still have the possibility to apply for a patent and get the patent granted to you. In Canada and the United States, this 12 months grace period work. Pay attention to other jurisdictions. So, next slide, please. So here we talk about copyright. That's very much a form of IP that is very much applicable to the creations from traditional knowledge. And they are original, what can be protected by copyright creations from the cultural field. I mean, original literary, dramatical, music, artistic creations. Keep in mind they have to be on a fixed form. That's quite important. And they have to have an author in order to have proper copyright protection. Though it's based on traditional knowledge, the author has to be identified in order to enforce the copyright. And the author assigns, or he or she keeps, the ownership of copyright and may enforce it. And it's quite an extensive right in the sense that it protects also how the work is reproduced, published, translated, performed. It's automatically open creation. Registration is advisable, and you'll register with the Canadian Intellectual Property Office in Canada. It's the form of protection I mentioned might be considered international because Canada signed many international conventions on copyright. The duration in Canada is the life of the creator plus 70 years. Next slide, please. So in the next slide, we talk about industrial design protection. Here, it's the shape, pattern, ornamentation applied to a manufactured article. And the example we have here related to a creation from traditional knowledge is a fabric that has this kind of ornamentation, original ornamentation. In order to get this kind of intellectual property protection, you have to apply, submit an image, a drawing of the design, and indicate from what field. Once you register your design, the registration is valid for 15 years, and after 5 years, you may you have an a maintenance fee that you have to pay. And after 15 years, it becomes public domain. So registration is highly advisable in order to have this kind of protection. It doesn't have protection under common law like for trademarks. And there is a grace period like for patents, 12 months. It's not advisable to be used. Next slide, please. So trade secret is another form of IP that has been mentioned as the main type of IP that you find in Canada. It deals with confidential and valuable business information, may be product related or trade related. Maybe any kind of information. And here in this example, you see a trade secret related to so-called ceremonial information that dealt with traditional knowledge of a community in Australia. So that kind of author was stopped by because of the trade secret protection that was for this kind of information related to ceremonial information was stopped on publishing that particular book. So in terms of how this kind of protection works, you simply document what you have as a trade secret information. If it's product related or trade related, you keep track of that, and you also take security measure to keep it confidential. That's quite important in order to enforce this kind of intellectual property right. It lasts as confidentiality is maintained. And in many instances, you develop an invention and you keep it secret in the very beginning before making this kind of decision to patent it. At that moment, you have to disclose the invention in the patent document if you want to have the patent granted to you. This is the trade-off that you make with the government of a country. You disclose an invention and you obtain the patent of that country in exchange for that, and following other rules as well. So it's important to keep information, especially for inventions, confidential before making that kind of decision. Next slide, please. Let's now talk, coming back to trademarks. So that was the parenthesis or the part of the trade of traditional knowledge creations and interactions, or how its intellectual property is applicable to creations from the traditional knowledge. So the trademark contribute a lot to the value of a brand, but not only the trademarks. Trademarks is probably the main contributor to the value of a brand, but other forms of IP kick on. We've seen actually the industrial design, the shape of Coca-Cola bottle, how it contributes to the value of the brand Coca-Cola. You also had an example of copyright, how this form of IP contributes to the value of the brand Michelin, for example. But the trade secret might have a role too to play in building the value of the brand. The inventions as well. People buy, or they consider a valuable brand that kind of brand that is also associated with inventions, patents, and in that situation. Next slide, please. So here we have a ranking. It's a little bit old, this kind of ranking, but anyway, that shows how much value brands have. And you can trade this kind of value. It has been said that Coca-Cola company actually can lose all their facilities, but if they will keep the protection of their brand alive, they will be able to reconstruct everything from scratch. That's how valuable Coca-Cola brand is. Here you have a ranking of different famous brands. Next slide, please. So the value consists first in the fact that you can have a source of revenue by licensing and franchising the trademark. You may also increase the value of your trademark by building in time the goodwill and the reputation of that particular trademark. So yeah, that's how you contribute to the value of the brand. And keep in mind that in the very beginning, when you adopt a trademark, it has little value, but in time that goodwill and reputation builds up and increases the value of the brand. And the trademarks are very much used to attract investors. That's how it works, and that's how brand value increases and gives you a powerful competitive advantage by having a very good trademark policy. Next slide, please. In summary, if I may, about the value of the trademarks or added by trademarks, first, it differentiates you. It sets you apart from your competitors, and also builds reputation and goodwill, has been mentioned before. So the brand can express much more than the trademark, express what your business stands for, what you want your business to be, like a high-end brand, or how your business is perceived in the marketplace. So that would be, in a summary, the value added by the trademarks to the value of the brand. Now, because we are towards the end of the presentation, let's go next slide, please, with examples of famous trademarks. So trademarks I mentioned, they might be logos, slogan, sounds. You have here an example of McDonald's trademarks relating to all types of identifiers. I mean, the logo, the slogan, I'm loving it, and also the sound that might be considered a trademark identifying McDonald's products and services. Next slide. Another case study is a famous Canadian trademark, Shopify. You have the logo. Logo contains also the word trademark in a particular font, plus that image of the bag with an S on it. And the word trademark is Shopify, as simple as that. I suggest that you get a copy of this presentation and click on that and see other examples from our trademark database. So that will help you understand how the trademark system works and how you can take advantage of this system. Next slide, please. So that's another example of a famous Canadian trademark. You also have the logo, a famous logo, and the brand itself, or the word trademark, Canada Goose. Next slide. So if I may get the next slide, this is an example. I suggest that you look on our trademark database to see exactly what is registered and the list of products and services associated with that particular trademark. So in summary about the trademarks are sign or combinations of sign. We've seen traditional trademarks, word, logos, sounds, but you have also non-traditional trademarks. And you may have a combination, depends on your trademark or branding strategy. You may use a combination to have a combination of trademarks or signs that will be your trademark, and in that way you'll increase the value of your brand. Sometimes works just to have only a name. Nike, for example, would be a famous trademark. They have a slogan as well, just do it. But it depends on your business strategy, how when you start with an intellectual property strategy, you look at what you have and what your competition is doing in the same field of intellectual property. So you'll be able to make a wise decision by comparing yourself with others and how to move forward in terms of building your own intellectual property strategy vis-a-vis your competitors' intellectual property strategies. So, but trademarks, they help build reputation, goodwill, and they contribute to the brand value. That's quite important. Next slide, please. Also, keep in mind, as I mentioned before, that the trademarks should not be clearly descriptive. They are not considered powerful. The same with the person full name or surname. They are not registered at first, but you have to put a lot of money, time, and effort to make them work as a trademark, like an identifier of products and services pointing to just one producer. The name in any language of the product or services are not accepted trademarks, but again, exception would be when you use it again and again on the market and people get accustomed to that kind of product name or service in another language, and they associate it to who is behind. And obviously, a no-go is when you're interfering with someone else's trademark rights. You cannot have like a little McDonald's and selling similar products like McDonald's, and you'll interfere in that way with the legitimate owner of the McDonald's trademark. Next slide, please. A few words about this presentation was prepared by two organizations, main organization dealing with intellectual property in Canada. You have Intellectual Property Institute of Canada that is considered an association of registered trademark and patent agents and lawyers and other intellectual property professionals. So they helped us with the content of this presentation. You also have the contribution of the Canadian Intellectual Property Office. That's an agency of Innovation, Science and Economic Development Canada, and it administers main types of intellectual property in Canada. It's the Canada's Intellectual Property Office, I would put it this way, because it deals with patents, trademarks, copyrights, industrial design, integrated circuit topographies as well, and they administer all these rights. So in order to have a trademark registered in Canada, you have to deal with the CIPO and the particular trademark office. Also, it's important to go on the website of CIPO, because there you'll have a lot of information explaining from very basic to more detailed and highly professional information regarding the processing of patent and trademark applications. You have manuals, you have tutorials. If you are interested in getting patent protection yourself as an inventor, you are able to do so. However, as I mentioned before, it's highly advisable to use a professional who is skilled and may do it properly and professionally. So that's how you can do this kind of education effort, and also getting your intellectual property rights formalized, registered with the Canadian Intellectual Property Office by going on our website. It's quite well structured and quite easy to use. As I mentioned, you have videos, you have a web-based tool helping you on building an intellectual property strategy as well. So next slide. So Canada, you see the image of Canada and the flag, Canadian flag there. This is the brand of the Canadian federal government services. So that's our brand, so to speak. So this is the end of the presentation. I thank you very much for your attention.